inclusion under the heading extension of interim order.
Interim order is expired.
My lord, expiring on 31st 12. My lord, this after this bench, my lord, circuit will start from 2nd January, lordship. And my lord, one more submission, my lord, one hearing matter, lordship, 2023.
Just a minute. 23rd December, under the heading extension.
Lordship, one hearing matter of 2023, lordship.
What is the urgency?
My lord, urgency is this, my lord, the recent order passed by the chairman of Jalpaiguri Regulated Market Committee, my lord, with an observation that 64 stalls, which are the issue, my lord, they are not, my lord, established haphazardly, which is, my lord, in violations. This observation is
Affidavits have been exchanged.
yes, everything completed, my lord.
This circuit, I have already included some of the hearing matters. Let me see how far I can.
My lord,
Let me see. No, not at present.
Lord.
For quantum application, Lordship.
Arising out of the order passed by this court.
Yes, Lord, my Lord.
Tomorrow.
Lord.
Tomorrow.
Lordship, may I be permitted to mention a matter, Lordship?
Yes. Let me see if that similar matter I can take up, then I will take it. No further inclusion, sorry. Hearing, no further inclusion. Yes.
Inaction matter
Of hearing.
or mention stage.
Mention stage means?
Motion stage.
Motion stage. Writ petition of which year?
Or one party.
Writ petition of which year?
I am on the petition.
I won't have it there.
2024. Oh, yeah, 2024.
24. What was the last order passed?
Last circuit.
What was the order passed? Perhaps. So you read the brief and then mention his
Lordship, petitioner wants to withdraw the writ petition.
writ petition. Is it hearing stage or motion stage?
Lordship, it's motion stage, Lordship. This is infructuous. It has become infructuous.
Tomorrow to be mentioned, serve notice upon other side.
I'm bothering once again to your.
No, sorry, no hearing matter. Yes.
That extra, can it be taken up on Friday, subject to your lordship?
Why? Why not on Monday?
I'll go back.
Well, Friday to be mentioned. To Friday under the heading extension.
Permitted to mention one matter, Lordship. This is a hearing matter, Lordship. Similar matter in the list, Lordship. Item number 53.
Let me see some of the hearing matters I have
Lordship,
included.
if it, last
Similar matter, if I can decide this matter, then you mention. Otherwise, not.
Lord.
Hearing. When motion of which year? What relating to which issue? What issue? So what was the last one? Video. No order. Tomorrow. Sir, notice upon other side.
Lordship, may I on another pair, Lordship? Lordship, for inclusion in the list, Lordship, motion stage, Lordship.
Motion.
Yes.
What was the last order?
Last order, Lordship, there was the direction to file the report to the respondent, and that was filed, Lordship. And
When that was, yes, that was filed in.
12th November, Lordship.
Then what was the direction when matter would come up regarding
Next
inclusion?
circuit, Lordship. Next circuit, there was a direction next circuit.
Next circuit.
Yes, sir. I have already served the notice to the other party.
Tomorrow. No, then wait. If it is hearing matter, then wait. No. अच्छा दे रहा होता तो hearing में काल को देखना. Call the list. Why this has appeared under the heading to be mentioned in terms of the order passed by just a minute. Yes, have you filed your affidavit in reply?
I have not, this is the come automatically, I have.
No, it has not come. There is a direction. I have directed the matter to come out, not automatically. Why you have not filed affidavit in reply? 8 July 2024, a coordinate bench directed that the learned advocate appearing for the petitioner submits that till date he could not prepare his affidavit in reply. 2021 matter. Let affidavit in reply be filed within a period of 2 weeks.
Whatever, if not larger advocate, Devashi Banerjee appearing from Kolkata. GTA matter, the.
Whatever would be the matter, when the direction for filing affidavit was passed. What apology? I will not extend in time unless until you pay cost. Sorry, pay cost and get an extension. Otherwise, it will be treated as a ready for hearing matter. No, this will not continue.
I will request Devashi Banerjee to appear.
Don't name any advocate before this court. That will not cut any eyes. Why you are repeatedly naming an advocate? Will you get any advantage? If you go on uttering names, then I will enhance the amount of cost. I was thinking to impose the cost of 5,000, it will be enhanced to 10,000. On 21st December 2021, order was passed. And there is a direction for filing affidavit. Till date, no affidavit has been filed. Last occasion, coordinate bench on 8 July 2024 directed to file affidavit in reply within a period of 2 weeks. It has not yet been filed. From July, August, September, October, November, December, 5 months have passed. Yes.
That client will go through before doing the contacting advocate or there's a chance to withdraw the petition as well.
Then withdraw it.
And make it Friday, I will whatever.
Yes. Shall I record it that the petitioner wants to withdraw it?
So Friday, if the advocate will appear and do the matter, then.
What he will do?
He
Unless and until affidavit is filed, reply is filed. Whether it will be as per your discretion, then what he will do? Matter is not ready for hearing from 2021 December. There is a direction. Last occasion in the month of July, there is an order extending the time to file affidavit in reply. Apology will not do. Time to pay for apology has ended. Issue.
Lordship, I am appearing on behalf of the GTA, Lordship.
Matter has come up under the heading to be mentioned. Quote unquote. Full stop. By order dated 8 July 2024 of a coordinate bench, passed by a coordinate bench, time to file affidavit in reply was extended for a period of two weeks. Stop. However, till date, affidavit in reply has not been filed. Stop. As a last chance, next paragraph. Stop the next paragraph. As a last chance, time to file affidavit in reply is extended till till 9th January 2025, failing which no further opportunity shall be granted to the petitioners to file affidavit in reply, and matters shall be treated as ready for hearing. Stop. List the matter under the heading hearing. Under the heading hearing on 10th January
Lordship, is it
2025.
possible to fix the matter on 8th January, Lordship? 9th and 10th, I have some difficulty, Lordship.
On 10th January 2025, subject to convenience of the bench. Next.
Item number 2, my lord, I beg to appear for the petitioner, led by Mr. Vikram Bari. There was a direction for filing affidavit, but no affidavit has been filed.
Yes, what about the affidavit?
Embarrassing.
2021 writ petition, yes.
His place to have again asked for, because he will come to Kolkata and Miss Bose she's carrying the instructions. She's contesting the election.
Because
I have gone to the
2021,
record
no,
without affidavit also it
it's
will be
not a
done.
matter of contesting election. Because there is a direction to file
Yes,
affidavit.
there was a direction. That
File
instruction was
affidavit.
expressed, we have asked again.
This direction was passed
Long
on
back.
29 November 2021.
Long way. It is happening.
Then the pay cost, and I will extend it entry time to
Without
file
affidavit.
affidavit. Otherwise, let it be treated as ready for hearing matter. You may
Without
submit that
without-
you don't want to use any affidavit.
I have gone through because the instruction is that is the problem. I have gone through the
No,
record.
for if for last 4 years instruction is not forthcoming,
No,
then there will be no instruction. How long this will continue?
also for the last chance we are paying for the next circuit. Otherwise, in order may kindly be passed that otherwise it will be taken up hearing without affidavit. Because it was also missed to the record.
From 2021,
Yes,
you
I-
have not filed any
I have
affidavit
gone
of
through these
opposition.
orders.
Issue. Who is appearing for the, you are for the petitioner. Yes.
Lordship.
Matter has come up under the heading to be mentioned. To be mentioned, full stop. In spite of order dated 10 July 2024 passed by a coordinate bench, extending the time to file affidavit in opposition and affidavit in reply, till date it is found no affidavit in opposition has been filed by the respondents. Stop. Learned advocate representing the state respondents has prayed for extension of time as a last chance to file affidavit in opposition. Next paragraph. Time to file affidavit in opposition as a last chance stands extended till 9th January 2025, failing which writ petition shall be treated as ready for hearing. Stop. Next paragraph, list the matter under the heading hearing on 20th January 2025, subject to convenience of the bench.
For this statement.
Item number 3, 4 and another matter.
I'm for the respondent 2 and 5, my lord. 2, 3 and 4 and 5, my lord. Power Grid Corporation.
In this case, the petition before your lordship will challenge.
On the last occasion, they sought for leave to file supplementary affidavit, whether they are filing it or not.
In terms of annual court's order to the data amount, so no to the post of the by the consent of the
Yes.
Yes, supplementary.
The two orders were partner, one in justice. And now was justice, now was passing order to file opposition by the.
Where is the supplementary affidavit? In terms of the order dated 2nd May 2024, why have you filed supplementary affidavit? First, answer the query of the court. Have you filed supplementary affidavit? Why not? Why not? Then why you have prayed for supplementary affidavit? To delay the proceeding? Then
First, justice now is to direct the state to file opposition. To give the reason. And then in the course of hearing, I have come to know, the state government already approved the notification of the central government. And subsequent to the other states of India, they have also approved the notification, but the state of West Bengal also approved the notification, but it was not published in the newspaper or in nowhere. Within the course of it, I have submitted the document before your lordship, but that is not a publicized document that I can approve. But in the meantime, I request my client to come before your lordship, come to me and I told them that 2015 notification that the central government directed to all the states to comply to give the compensation amount to the land user of the high electricity board. So that was not approved by the state government. So I request them to withdraw the matter so that the competition as settled by 2019, so that you can get something that when the state government will approve the same, so I request them to withdraw that. So yesterday that the matter I tried to contact the client, I could not do that. I think the matter Friday. If it happens, I will do the.
According to my lord, according to Telegraph Act, my lord, we have already sent the check, my lord. That has not even been encashed, my lord. So far, my instruction.
Oh, what is the date? What is the date of the check?
My lord, long back, my lord. That is sent by post, my lord. Date was 15, my lord, 2015.
So then that check now cannot.
My lord, there is no information that check has been encashed or not by the petitioner, my lord.
So you take will you be able to take instruction whether the check has been encashed or not?
My lord, I will try my level best, my lord. Immediately, I will from my client to take back.
He's saying that you are representing Power Grid.
Yes, my lord. Yes.
So Power Grid is saying that a check was issued in favor of the president. Encashed. Now,
that has been annexed in the.
The check has not been encashed.
Check has not been
Encashed. So if check is not encashed, then you are required to issue a fresh check.
Yes, my lord, that is right, my lord.
That can be
And
done.
That can be done. my lord. Yes, my lord.
Yes, your lord.
If that case is not in case,
Tomorrow.
my lord, that's
Friday, my lord, Friday.
Why Friday?
Friday, so if they are in a remote area, my lord, sometimes, my lord, they are not. See, matter, my lord, I will give the another number.
Yes, one after another. Matter has come up in the list under the heading to be mentioned. Since in terms of the order dated 2nd May 2024, petitioner has not filed supplementary affidavit. 2nd May 2024, passed by a coordinate bench. Petitioner has not filed supplementary affidavit. Next paragraph. Learned advocate representing the petitioner prays for accommodation to obtain instruction whether petitioner wants to proceed with the matter or not. Stop. Power Grid Corporation of India Limited, being the contesting respondents, are represented by learned advocate, who has said previously a check was issued in favor of the petitioner for payment of compensation. But whether the check was encashed or not, that is not known to the learned advocate, to the said learned advocate. Stop. Next paragraph. List the matter under the same heading, to enable the learned advocate for the petitioner to obtain instruction whether the petitioner still interested to proceed with the matter.
my lord, nowadays the PUC has been paid by online, my lord. If not paid, my lord, not in cash.
So very well. Then the bank particulars are to be disclosed by the
Supplied.
petitioner, based on which within a certain time you have to make the payment.
Yes, my lord, that.
Obtain instruction.
My lord, matter lapping the list on Friday, my lord.
Yes,
Matter
Friday under the heading to be mentioned.
My morning.
To be mentioned, yes, Friday
Yes.
morning.
My lord, kindly give me some intelligence, my lord. Kindly fix at 2 p.m., my lord.
No, not
On
so.
that occasion, my lord, I
Please appear.
okay.
Same issue.
Same issue, compensation by Power Grid.
Or.
Same order. देखिए आगे ম্যাটারটা একটু দেখি, আগে জাস্ট ফাইলটা দেখি। উঠে যাচ্ছ কেন? বসুন, দাঁড়ান। উত্তম কুমার মন্ডল, 325 সেম অর্ডার। Now, what is the position? Who is appearing for the petitioner?
None is appearing for the petitioner. The petitioner is otherwise not found eligible. Even after the order passed in the earlier petition, considering her as an SC candidate. My lord takes up page number 82, my lord, the last annexure P40. Her marks is better than the last qualifying candidate in the SC category.
No, position is, situation is different since a coordinate bench
Well, that has been taken into account.
passed an order
Yes.
on 6th February 2023,
Yes, my lord.
directing the matter to be heard by the bench at the principal,
Principal bench, yes.
by the court at the principal
Principal
bench,
bench, yes.
since similar other matters are pending before the bench.
Before the principal.
Now, pursuant to that order, Honorable Chief Justice assigned the matter to a particular bench, single bench.
Gotcha.
Now, that bench is not available.
Not available.
today.
That is the.
Now, this assignment was done on 15th February 2023.
Wait.
Thereafter, order was passed by the bench where this matter was assigned on 20th February 2023.
Yes.
On subsequent on 14th September 2023, a coordinate bench directed the registry to transmit the records to the principal
Principal
bench.
bench. That was the last order.
So now, are you aware of that the similar matters are pending before which court?
My lord, regarding this particular matter, I might inform the court that this petitioner is otherwise not found eligible because her qualifying marks is less than the last qualifying
So
candidate
do one
in
thing,
the state category.
do one thing, let me direct the department to communicate, to serve notice upon the learned advocate as well as the petitioner.
Lordship.
And I'm fixing a date on
Lord.
that date with the, because in absence of the
Lord.
representation on behalf of the petitioner, no
Lord.
order should be passed
Lord,
today.
about
Since several orders were passed and the
Lord.
matter needs to be heard by a bench, that bench is not
that
available.
bench is not.
So there are certain difficulties
Lord.
today based on your submission to dispose of the matter finally.
Lordship. I will, lordship.
Issue. On perusal of record, it appears that the then Honorable Chief Justice by order dated 15th February 2023 assigned the matter to a coordinate bench, assigned the matter to Honorable Justice Obhijit Gangopadhyay. Stop. The matter was heard by that bench on 20 February 2023 when West Bengal Board of Primary Education was directed to file affidavit within certain time. Stop. Next paragraph. Subsequently, matter was the writ petition. Subsequently, the writ petition was heard on 14 September 2023 by another coordinate bench, thereby directing the records to be transmitted to the principal bench it's February 2023. কি বলছেন subsequently?
Subsequently, the requisition was heard on 14th September 2023 by another coordinate bench, thereby banishing the record to be transmitted to the principal bench.
Stop. Next paragraph. However, matter is placed before this court today under the head, ওটা কি আগে বলেছি to be mentioned দেখো তো। However, matter is placed before this court under the heading to be mentioned. কেটে দাও সেন্টেন্সটা। Today, it is found that situation has been altered since the bench which was assigned, since the bench to which this writ petition was assigned by the then Honorable Chief Justice, video order dated 15th February 2023 is not available. Stop. This court has determination sitting on circuit at Jalpaiguri to take up writ petition petitions under any head and under any group or under all groups. Next paragraph. Learned, you are for the state. Learned advocate representing the state respondents submits that the petitioner is not eligible to be considered for appointment in the post of primary teacher. Primary school. In the post of primary teacher, since the last candidate who was selected got higher marks than the petitioner. Under the category of the petitioner. Stop. Next paragraph. Today, petitioner is not represented. Stop. Registry is directed to communicate this order to the learned advocate representing the petitioner as well as to the petitioner by 1 week after Christmas vacation. Oh. Who is advocate? Mr. Subhashish Mishra? Just yes, Sunil Kumar short.
Yes, sir.
Acha. Last sentence কি বলছিলাম দেখুন।
Registry is directed to communicate this order to the learned advocate representing the petitioner.
না প্রথম থেকে পড়ো ওই লাস্ট সেন্টেন্সে কি বলছিলাম, রেজিস্ট্রি ইজ ডিরেক্টেড টু, তার আগে একটা লাইন অ্যাড করো। It is also submitted, it is submitted on behalf of the state respondents. It is submitted by the learned advocate representing the state respondent that advocate on record for the petitioner has died. Stop. Hence, registry is directed to communicate this order to the petitioner by 1 week after Christmas vacation and submit a report on the next date. Stop. List the matter under the heading to be mentioned on January 2025, subject to convenience of the bench. তাহলে আগের সেন্টেন্সটা হচ্ছে না কিন্তু কেটে দিয়ে যে ডাইরেক্টিং দ্য রেজিস্ট্রি টু কমিউনিকেট দিস অর্ডার টু দ্য লার্নড অ্যাডভোকেট অফ দ্য পিটিশনার এন্ড দ্য পিটিশনারটা কেটে দাও
এটা তো শর্টে আপনি আমার
ইয়েস ইয়েস
number six.
Yes, affidavit. Yes, Mr. Dhar, affidavit. Why? Why? Just a minute. Where is it? Yes.
By this common notice, 6 owners of the godowns, they were called for a hearing. Now they came for the hearing, they could not produce the building plan nor any permission. Those for running a godown of prior permission from the corporation, they could not. Ultimately, notice was, they were directed to remove. It would also end up to page number 33.
Yes.
Despite serving the opposite duties, the commercial activities are still being rendered by you, the same public structure go down at your opposite premises. Now in process of section 27, you are directed to stop the operations, forfeit and demolish the operation.
Construction.
Now challenging this notice only out of the 6, only in this petition, Pankaj has come. Now he failed to obtain any bonus. Against that, he did not prefer any appeal. We waited for 1 month, thereafter we demolished. We demolished all the 5. In one stage, there were 5 godowns, all godowns have been demolished. Now that action of demolition has not been further challenged. So this petition, I believe my understanding is this petition to come in your place.
Where is the learned advocate Isha Acharya? Do one thing. I will direct you to serve notice upon the learned advocate for the petitioner. And I'm placing this matter on Monday for further consideration. And in the meantime, the learned advocate would obtain instruction whether the petitioner wants to proceed with this matter or not. Matter has come up under the heading to be mentioned when one appears for the petitioner. Stop. However, the learned advocate representing Siliguri Municipal Corporation submits that the impugned order dated 23rd August 2022 passed by the Commissioner Siliguri Municipal Corporation has been given effect to by demolishing the godown. Since there was no interim order restraining the restraining the corporation from demolishing the unauthorized structure. From demolishing unauthorized structure. Stop. It is submitted by the learned advocate representing the corporation that the matter has become infructuous. Stop. Since petitioner is not represented today, learned advocate for corporation is directed to serve notice in course of this day upon the learned advocate representing the petition. Stop. On receipt of such notice, learned advocate for the petitioner is directed to obtain instruction whether petitioner is still interested to proceed with this petition or not. Stop. List the matter under the heading to be mentioned on Monday next, 23rd December 2024.
Grateful evidence.
Item 7, I am for the petitioner. So instead of repeated opportunities, affidavit has not been filed. Lastly, on 25th of January 24, last chance was given. Kindly see, my lord, 25th of January. Peremptory chance was given on 20th.
Where is Mr. Shubin Kumar Saha? Why affidavit
No, we are
has
filing.
not been filed? Today you are filing?
No copy has been served upon us.
Please check for annexure lo dekhe.
Well, you file reply within 1 week after reopening. Mr. Banerjee, file reply within 1 week after reopening. And I'm directing the matter to appear on 28th subject to convenience. State is the main contesting respondent.
And also SDGO, they are also party.
Let them. Yes, Mr. Saha, whether you want to file any affidavit in opposition.
Let short extension, let I will. Let in a analogous
extension, very well. I am extending for a period of 1 week. Payment of 10,000 rupees cost.
Not kindly, so far as there is an analogous.
The initial order was passed.
Yes.
Affidavit.
Mainly, this is a land acquisition matter. We are requiring body. State is the main respondent. They are supposed to give answer.
If you do not want affidavit, tell me. Then I will record that no affidavit is to be filed by SGDA and matter to be treated as and in future no opportunity shall be granted to SJDA in this matter to use an affidavit.
But kindly,
if you want extension, then there be an extension on payment of cost of rupees 10,000.
But kindly,
this order was passed on 3rd November 2022. Subsequently, extension was passed on 25th January 2024.
There is a mistake.
1 year has passed, and initial order was 2 years back.
There is a mistake on my part. There is an analogous matter that is 2552. This is 2551 WPA number. In that matter, affidavit has been filed by the SJD. I was under wrong impressions that here also affidavits have been filed. Later on, I am seeing that no affidavit is filed here. So I am seeking lordships. Kindly reopening day. On a reopening day, I shall file lordship.
Yes,
if you
very well, then it will be brought down to the cost will be brought down to from 10 to 8,000 rupees.
But kindly do not. Otherwise, matter will not be delayed.
It's not a matter of right, Mr. Saha.
No, I'm not. I'm not seeking right. It's my mistake. I'm submitting before lordships. I made the mistake, lordship. Since two matters are analogous, it was my
on the reopening date on 2nd January, you will file your affidavit as a last chance. In which no further opportunity will be granted to you to file any affidavit.
Lordship.
Yes. issue. Matter has come up under the heading to be mentioned. Matter has come up in the list under the heading to be mentioned. Stop. Court has heard the learned advocates representing the petitioner, comma, state respondents, and Siliguri Jalpaiguri Development Authority. Stop. Next paragraph. On behalf of state respondents, affidavit in opposition is filed today and same is taken on record. Copy, have you served a copy of Mr. Copy of the affidavit in opposition has been made over to the learned advocate representing the petition. Next paragraph. Mr. Raja Saha, learned advocate, appears on behalf of SJDA on virtual mode and prays for extension of time as a last chance to use an affidavit in opposition. Stop. Next paragraph. Time to file affidavit in opposition on behalf of SJDA stands extended by 2nd January 2025, failing which no further opportunity shall be granted to SJDA to use affidavit in opposition, and matters shall be treated as ready for hearing. After affidavit in opposition to be filed by the, after affidavit in reply to be filed on behalf of the petitioner within the time which is stipulated herein below. You want to use any affidavit in reply?
Yes, my lord, I shall.
Herein below. Stop. Next paragraph. Time to file affidavit in reply stands extended by
I'm on behalf of the state respondent, my lord.
yes, affidavit in opposition by the state and Union of India. You are for the Union of India. Where is the affidavit in opposition?
Yes, my lord. My lord, I have been re-allotted this case, my lord. I've gone through the brief, my lord. There's not requirement and the order can be passed in this case as because, my lord, the page number 22 shows a show cause notice where the date of reply.
Why you did not submit this at a time when the order was passed? That is not the that should not be the explanation.
It is
On 9th November 2022, this order was passed.
my lord.
Then you should have the land advocate representing the state
My lord,
could have submitted that we don't want to use any affidavit.
My lord, recently an order has been passed in this regard that if in the show cause notice the date is not given, my lord, then a fresh show cause notice is required to be given.
Matter relates to?
Matters relates to GST, my lord.
Yes. The show cause notice was filed.
My lord, a show cause notice was given to it. And that show cause notice doesn't reflect the date and time of hearing, my lord, and also do not specify the place of hearing, my lord. And with that regard, there is a specific judgment, my lord, of the single bench, my lord, where it is clearly stated, if that is not done, my lord, the show cause notice is bad in law, and they have to be given a fresh show cause notice to that court, my lord. And I have the judgment to that. And
So,
that has been passed
have you
on
issued fresh show cause notice? No.
No, no, my
So,
lord.
due to pendency of this writ
This
petition.
writ petition, my
Who
lord.
is appearing for the petitioner?
My lord.
Mr. Miss Swarnali Ghosh Sengupta is the advocate on record, perhaps. Pradut Banerjee and Orijit Ghosh. He is regular in this court. Serve notice upon him. Serve notice upon him so that I am fixing the matter on Monday.
But I'll say him.
Yes, you just serve a notice, and I am recording your submission that you don't want to use any affidavit. And on behalf of the central government, Union of India, no affidavit is required as it is submitted.
My lord.
So he is to obtain an instruction. Let me see if the matter can be disposed of on Monday.
My
Matter has come up in the list under the heading to be mentioned. Quote unquote to be mentioned. Stop. Learned advocate representing the state respondents on instruction submits that the state authorities are not willing to file affidavit in opposition, since the show cause notice which is under challenge in this writ petition is bad, requiring issuance of fresh show cause notice. Stop. Learned advocate representing Union of India submits that no affidavit in opposition is required to be used on behalf of central authorities. Stop. Next paragraph. In view of submissions made on behalf of the respondent authorities, matter is treated as ready for hearing. Since state respondents as well as central authorities, since on behalf of state respondents and Union of India, it is submitted that they are not willing to use affidavit in opposition. Stop. Next paragraph. However, petitioner is not represented today. Learned advocate for the petitioner, learned advocate for the state respondents is directed to serve notice enclosing copy of this, directed to serve notice in communicating this order upon Mr. Orijit Ghosh, learned advocate, who is representing the petitioner by in course of this day. In course of this day, yes. In course of this day. Step. Next paragraph. List the matter under the heading hearing on Monday next, 23rd December 2024. Next paragraph. On receipt of notice, learned advocate representing the petitioner shall be at leave. Learned advocate for the petitioner shall obtain instruction. Stop.
I'm grateful.
Number 9.
Copy গুলো দেখতে হবে এরকম থাকে পুরোনো এগুলো সব মেলে
Yes, affidavit in opposition.
we are filing this.
You have filed. Where?
We are filing today.
File it.
না চেক করে নিয়ে কপি
National Highway Authorities not represented today. Supriya Singh.
She was here.
She was here in the morning.
Where is she?
Where is she?
Yes, file affidavit in opposition.
ঠিক আছে দেখিস তো
Matter has come up in the list under the heading to be mentioned, quote unquote, to be mentioned, full stop. Learned advocate representing the state respondents has filed affidavit in opposition, which is taken on record. However, petitioner and National Highway Authority of India, National Highways Authority of India are not represented today. Stop. List the matter under the heading. No, stop. Order B. Are you aware of that who is appearing? Mr. Petitioner Debayan Goswami. Whether he is regular in this court, Debayan Goswami.
Junior.
Yes, then
Or junior.
your junior, then there's a direction for affidavit. Far back on 10th November 2022. Now, today, state is filing affidavit in opposition. National Highways Authorities is not represented today.
No, it is.
Yes. Do you want to use any affidavit in opposition in this matter? Tell me.
Lordship, I have missed the brief, Lordship. Not doing any.
Very well, I am doing one thing. If you want to use an affidavit, use it by 2nd of January. Then the time to file affidavit reply shall be extended by 9th, matter to appear on 20th. Taken on notice. Stop. আচ্ছা তারপরে কিছু বললাম না, not represented. ওটা কেটে দাও, এটা দুজনেই appear করছে. Stop.
But may I be allowed to say something?
Yes, yes.
If I remember correctly, this is a case wherein there was a title dispute. If that is what the case is,
Which dispute?
title dispute in respect of the property. If that is what the case note says, then as per 3H4 of the National Highways Act, this has to go to this is a reference.
No, don't make it cut short at this stage, because there was a direction by this court. This point was not taken. So if this point would have been taken before at the motion stage, matter could have been disposed of. Now the state has used affidavit, you are saying no. Or you can make up your mind on the next date, you can submit that you don't want to use any affidavit. The matter to be heard finally without any affidavit in reply on behalf of the petitioner. Next one. Petitioner and National Highways Authority of India are represented by learned advocates. Stop. Time to file affidavit in opposition to this writ petition by National Highways Authority of India stands extended till 2nd January 2025. As a last chance, failing which no further opportunity shall be granted to the National Highways Authority of India to use any further affidavit in opposition. Stop. Time to file affidavit in reply stands extended by 10th January 2025. Stop. List the matter under the heading hearing on 20th January 2025, subject to convenience of the bench. Survey copy upon Mr. Mishra, copy of the affidavit in opposition filed on behalf of the petitioner, filed on behalf of the state respondent, is made over to the learned advocate representing the petitioner.
21.
Done.
Appointment.
Yes, call the next matter.
Number 10, and for the petitioner. For the matter pertains to overdrawn and wrong date exception. The petitioner.
Affidavit in opposition.
But the petitioner is relying on our document, my lord, text of page number 30.
So you have not used any, you will not
No,
use any
it is
affidavit in
not
opposition.
required. It is the school who has to file the affidavit. The DI has already made a communication according approval for provisional approval for refixing the pay of the petition. This increment which is being sought, higher financial benefit.
Thereafter, if my lordship is of opinion, then not, we can wait for the opposition to come.
But your learned advocate representing the state prayed for time to opportunity to file affidavit in
I believe that
opposition.
secondly, it was done because it is the school.
And both of you were present.
Yes, takes up page number 36.
No, but what about the order? Why this point was not taken at the time of moving the writ petition? Learned advocate for the state pressed for
Yes.
filing affidavit
Yes,
affidavit for opposing the contentions advanced on behalf of the petitioner. And also I find that the writ petition cannot be decided. That is the finding of the court in
yes.
view of the submission made on behalf of the state respondents.
My lord, the earlier paragraph.
Then I will impose heavy interest on this overdrawn amount. Because this order was passed on 3rd July 22, but it's a pension matter.
Yes, my lord.
So from the pensionary benefits, this amount has been deducted. If you do not file affidavit in opposition today, after 6 months, if you take this point, then be ready that I will impose exemplary
Fix it on 2nd January in the meantime.
Yes. Otherwise, following Rafiq Masi, the matter could have been disposed of on that day.
But it keeps it on 2nd January then.
It's still working. It's not.
Oh,
It's
still
just a
working.
pension. It's a higher increment.
At page 43, so initially what happened was I joined the BA pass, and within 5 years I had to complete the BA degree. At page 43, my lords will find that such date was extended up to 2012. It's one paragraph I will read it from the lordship. In reference to this memo number such and such, on the above notes of the undersigned is likely to say that as per existing rules and provision, 4 increments are allowed to the assistant teacher during the first 5 years of service, within which they have to complete the B.Ed course approved by NCT. As during the period of court cases continued for the last 3 years, the incumbents concerned were unable to get themselves admitted to the B.Ed course in the college approved by NCT. The governor, after careful examination of all the facts and circumstances of the case, has been pleased to allow the incumbents in drawing increment up to the year 2012. Which means if somebody has passed before 2012, then this increment should be applicable to them. In my case, page 19.
Yes.
At page 19, we will find that I completed my B.Ed in 2008. So it was, although.
When you were appointed?
2001. So I had to do it within 5 years.
So how you have done
5 year
this?
period was extended till 2012. during which period
Just
they
a
must
minute,
have to complete the.
understand it.
Initially, once I was appointed in 2001.
Just a minute.
At that time,
You were appointed in 2001.
2001. At that time, the rule notes was that within 5 years, somebody has to complete the BA.
Not at that time. It is the rule.
As an exception, what was done was that till 2012, that opportunity was extended. I completed nursing in 2008. At page 19. And therefore, my pay was rightly revised in 2009 OCA. But what they did was after 18
No,
years,
then page 43 you are relying upon. And what are the other documents?
page 19 is my certificate, BEd certificate.
Page 19.
19, the mark sheet is there at page 18. 19 is my certificate. It's dated 11th of March 2008. One has to see it at the bottom.
And by which order this overdrawn was found? By
I was asked to return the amount, that is here. I'm so thankful. At page 30, will find.
Page 30.
Yes, it's a little incomprehensible, but it says that higher benefit.
Not legible.
Not legible, but it says that normal increment from such and such is not admissible.
Page 30.
3030.
That was the direction for refunding the.
That was the direction for refund, upon which I had to refund an amount of 1,25,593.
So this was a direction by the district institute school.
Yes.
So let it be decided by the Commissioner of School Education on the anvil of
page 40.
On the anvil of page 43.
And my lord, this is my lord takes up page number 36 as well. My lord.
And since the school is not represented today,
Yes, my lord.
so I will direct the Commissioner of School
Yes,
Education to grant opportunity to the petitioner,
Yes, my lord.
as well as the school authority.
And to
Because
the school.
this order was passed in view of Tulsi Box's case was
Yes.
pending at that point of
At
time
that-
before the Honorable Division Bench.
Yes, my lord.
Whether the BEd colleges were required to be approved, affiliated by the NCT,
NCT
or
or not.
not. Lot of BEd colleges came in at that point of
No,
time.
North Bengal University.
Yes.
Not for,
Why
Other-
this
other
extension
BEd.
was done?
Why they are
North
doing
Bengal University is college is affiliated. That I've seen, but lot of colleges came which were not affiliated to
The private BEd college.
NCT.
Private BEd
Now,
colleges.
NCT rules were under consideration.
Yes, ma'am.
There, ultimately, the Honorable Division Bench, presided over by Justice Sirpurkar at that point of time, they held, and Honorable Justice Dipankar Dutt was appearing for the petitioners. I still remember, held that this is a public interest litigation, and held that no BEd college can continue without a formal nod and approval or affiliation by
From
the
the
NCT. So then those affiliation goes.
Yes.
So in view of this turmoil, those candidates who took admission in colleges which were not affiliated to
But could not
NCT,
complete, yes, but could not complete.
their course was under jeopardy.
Jeopardy.
So they had to take further admission. So due to this, such topsy-turvy situation,
Could not
this,
complete within 5 years.
order was passed in 2009, extending the time.
Yes.
Because this was not the failure on the part of the candidate to get an degree, because the situation was volatile at that point of time.
Lordship.
So let it be
My
decided by the
director
commission.
is Commissioner's Collateral.
Otherwise, this is the persistent
Yes.
norm that the teacher
Within 5
has to
years.
obtain within 5 years.
That is the rule.
Issue. Matter is heard in presence of the learned advocates representing the petitioner and state respondents. Stop. However, Andoron Fulbari Girls High School, Kuch Bihar is not represented. Petitioner was appointed as an assistant teacher in 2001 in the aforesaid state school. As an assistant, petitioner was appointed as an assistant teacher in the state school. 2001 बोल ना, state school, and obtained B.Ed qualification in 2008 from North Bengal University. Stop. In the writ petition, challenge has been thrown to
Overall amount of 125,590.
order dated 4th February 2019, page 30.
Not, it is 4th December
4th
2000.
December, 4th December 2019. Issued by the District Inspector of Schools, AC, Kuch Bihar. Deciding requirement of deciding requirement to refund alleged excess drawn amount by the petitioner. But it pertains to 18-year service benefit.
At the time of 18-year service benefit, it was realized that I have overdrawn because of my B.Ed and all.
আচ্ছা তাহলে কি বলছিলাম বলো তো লাস্ট সেন্টেন্স
in the petition challenge has been thrown to order dated 4th December 2019 issued by DISC Coach Bihar deciding requirement to refund alleged excess on amount by the petitioner.
At the time of considering sanction of 18-year service benefits to the petitioner. So it is submitted on behalf of the petitioner. The reason of calculating such excess drawn amount was failure by the petitioner to obtain B.Ed qualification within the stipulated period of 5 years from the date of her appointment or his appointment?
Her appointment.
Her appointment. Stop. In support of contention, reliance is placed on a communication dated 30th July 2009 issued by the OSD and ex officio Joint Secretary, School Education Department, whereby due to pendency of court cases, time to obtain B.Ed qualification was extended till 2012. It is submitted on behalf of the petitioner by Mr. Mishro, learned advocate. since petitioner obtained B.Ed qualification in 2008 from North Bengal University, she is entitled to get the benefit of such communication dated 30th July 2009, and there was no occasion to curtail her incremental benefits in connection with B.Ed qualification. According to the petitioner, curtailment of incremental benefits relating to B.Ed qualification was the reason to calculate such excess drawn amount, which is reflected from the impugned order dated 4th February 2019. Next paragraph.
December 1.
4th December 2019, right, 4th December 2019, stop. State respondents are represented by learned advocates. However, the state school authority is not represented today. Next paragraph. Having considered the submissions made on behalf of the petitioner, as well as the state respondents, this court, state respondents, the writ petition stands disposed of, directing the Commissioner of School Education, West Bengal, being
But he has not been made a party. Has to be added as a party.
Director, President, Deputy Secretary, Extension, additional extension, Commissioner of School Education, West Bengal, being respondent to decide the entitlement of the petitioner to draw incremental benefits without to draw incremental benefits from the date of her appointment in 2001. In consideration of the communication dated 30th July 2009, issued by the OSD and ex officio Joint Secretary, School Education Department. Stop. The Commissioner of School Education shall grant opportunity of hearing to the petitioner and the said school authority or their representatives and pass a reasoned order by 12 weeks from the date of communication of this order, and same shall be communicated to the parties within 2 weeks thereafter. Stop. At the time of consideration of the issue by the commissioner, petitioner shall be at leave to rely upon all relevant circulars, including communication dated 30th July 2009. Next paragraph. Till decision is taken by the Commissioner of School Education, impugned.
But she has already deposited.
That amount has already been paid.
Or already refunded back.
Oh.
So
It has already been refunded.
yes.
Stop. No, but unless and until this is set aside or
No, that has to be
kept
set
in
aside, but-
abeyance, I cannot direct the Commissioner of School Education.
That has to
Kept in abeyance,
yes.
kept in abeyance.
That is what I was doing. I was about to direct, but both of you have intervened.
I beg your
Interrupted
pardon.
me. Yes.
I beg your pardon.
Yes. Yes. The impugned order dated
4th of December 2009.
just a minute. Which page?
This page 30.
30.
30.
Dated 4th December 2019.
Okay.
Issued by the District Inspector of Schools within bracket AC close bracket Kuch Bihar shall be kept in abeyance. Stop. Next paragraph. Leave is granted to the learned advocate representing the petitioner to amend the cause title of the writ petition in course of this day and add Commissioner of School Education, West Bengal as additional respondent. Stop. However, service of notice upon the additional respondent stands dispensed with
All right.
since state respondents are represented by learned advocate. Dispose of, বলেছি dispose of that. Urgent xerox certificate করুন.
Grateful.
Next, এখনো 12টা বাজিনি, যা, চটপট করুন। Next.
Lordship, on behalf of the petitioner, Lordship, it is a hearing matter, Lordship. It has been wrongly tagged under motion, Lordship.
No, it is
Lordship,
not tagged under
I am-
hearing motion. It's to be mentioned.
Lordship,
Lordship,
Today I am hearing it under the heading to be mentioned.
Lordship, affidavits have been exchanged, Lordship.
Lordship, I am for the private respondent. I have appeared today,
Just a
Lordship.
minute.
Hmm.
This is WPA 2678 of 2022.
Lordship.
Now, the report dated 14 November 2024 says that no affidavit in opposition and reply is filed.
Lordship,
Where is your opposition?
Yes, state, Lordship.
But nothing.
Affidavits have been exchanged, Lordship.
The council opinion on behalf of the state is for some more time to find the affidavit in opposition. But on
No,
in
okay, appear.
2023, it is recorded that a client advocate appearing for on behalf of the state pressed for some more time to file affidavit in opposition.
Lordship, I'm for the petition.
Yes, where you have
Lordship,
filed?
I am for the private respondent. I have first time appeared before the Lordship.
Yes, Mr. Borgon.
Lordship.
File,
Lordship.
we file the report.
But there is a direction for filing affidavit in opposition.
Because it is a clearly private dispute.
Lordship, may I submit one thing, Lordship?
Regarding-
Lordship, in regard to the dispute, Lordship, the same has been, they sought for the relief before the Lordship Civil Judge Junior Division at Lordship Metliganj. If you Lordship kindly hand over the.
No, question today I will not enter into the issue.
Lordship.
Because there was a direction for filing affidavits.
Lordship, it was, I have appeared for the first time
So
today,
you take
Lordship.
these points by filing an affidavit.
Lordship, let me file affidavit.
What relief you are seeking?
It has been,
Madam, what relief you are seeking?
Lordship, I need to seek instructions from senior Lordship.
Lordship, it's entirely not maintainable, Lordship. It's barred on the doctrine of res judicata, Lordship.
Accommodation, Lordship.
The same, I am the party as a defendant in the suit, Lordship.
Obtain an instruction whether still you want to proceed with the matter, petitioner wants to proceed with the matter.
1 day accommodation, Lordship.
Issue. Client advocate representing the, no, stop. It needs to be recorded here in that in spite of direction for filing affidavits, for exchanging affidavits between the parties, till date, no affidavit in opposition has been filed by the respondents. Next paragraph. Client advocate representing the petitioner prays for accommodation to obtain instruction whether petitioner wants to proceed with the writ petition or not. Next paragraph. List the matter under the heading, under the same heading on Friday next, 20th December 2024 in order to enable the client advocate for the petitioner to obtain instructions.
Lordship, one indulgence, Lordship has placed that respondent has not filed affidavit. Lordship, I appeared for the first time. Private respondent is willing to file affidavit in opposition.
No, if petitioner wants to withdraw, then no affidavit is required.
Lordship,
Let her
Lordship,
take
as far as
instruction.
law, Lordship, no affidavit seems to be required if Lordship,
You
if
did
I
not
needed, I
appear
will
at the
give.
time of moving the
Because,
motion.
Lordship, because I was not present
So
at
let
that
her
time.
take instruction.
Lordship.
Issue. Yes.
My lord, the resolution has been taken in the principal bench. But the demise of the Supreme Court.
So you follow the resolution.
Yes, it is followed.
Still it is followed.
He was very close to me. I remember I want to say for
Subroto Rai. Yes, it has been sent to us by on WhatsApp from the protocol wing of High Court. I have seen in which bar he used to sit. Yeah. Do you know him?
Yes, yes. I'm showing his photograph.
Yes,
You
show me.
recognize him.
Show me.
He was in the
By name, I cannot recognize him.
14. Bar number 14.
14. What about other courts? In our bench, other court, two courts.
He was in a criminal kind of a state.
Let me see.
Very smiling face and very cordial behavior. Blue shirt.
Wow. Yes, I know him very well.
Yes. And
The fifth person, what happened to him?
Details not known, my lord.
In my court also. This court will can't say anything. But the advocate, I now by face I know him.
Yes, yes.
He is regular. Yes.
I remember that 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29.
29, my lord, I beg to appear on petitioner, my lord. Kindly, my lord, make it not today because, my lord, in the Calcutta also, my High Court, my lord, in the principal bench. Today is, yes.
Are you aware of what has happened to Mr. Rai? Who has
Sudden attack, my lord. Yes, no, yesterday night, my lord, I heard that.
cardiac attack?
Cardiac attack. Arrest.
Yes, very not today. Not
My
today.
lord. Right.
30, 31, 32, 33, 35, 35, 36, 37, 38, 39, 40, 41, 42, 43, 44, 45, 46, 47, 48, 49, 50, 51, 52, 53.
ये सुमेन তুমি কি মানে নামে চিনতে আমি না বুঝতে পারছি না আমি এটা দেখলাম ডকুমেন্টে আছে